Trump has the presumption of fair operation and good dealing to deport these people, as has been the tradition since forever until Trump came into power. So automatically, just email autoresponder goes out. Actually, you're injuncted. What? They say you can't do that. You're the judge. Trump administration didn't get any due process. The American people who elected Trump and this administration to effectuate these removals, we don't get any due process. And the court, when they're issuing their orders, don't even provide due process according to their own rules.
We're going to concentrate on national security threats and public safety threats, and that's what we're doing. After the Iran issue this weekend, we just stepped on the gas, adding a lot more resources to it and really hammering it. So we're on it. We're going to do the best we can as fast as we can.
Trump strikes back, files a lawsuit against the entire district court. That includes a bunch of other judges, not just one judge, but this is unusual. We don't see a lot of this here on this channel or in this country, really. We have this happening where the United States of America, Homeland Security are coming in as plaintiffs, and they're suing all the judges. The chief judge, George Russell, Abelson, Bennett, Blake, Boardman, Breder, Chesanow, Theodore Chuang, and we've covered cases from him that have been adverse to Trump. Gallagher, Grigsby, Hollander, Herson, Maddox, Ruben Zenas, who is handling the Kilmar civil case, not the criminal case, all being sued, including the clerk of the court and the United States District Court for the District of Maryland. Dang, son, all getting sued. So we'll see what happens here and what the judges do, because they're now defendants in this case. And something else that's interesting here, just procedurally and tactically, is now that they're sued, Trump also submitted this. Guess what? You're defendants in a lawsuit. So since we're suing you, you can't judge our cases anymore. So you must recuse yourself under the rules. All of you, get off our cases right now. Saying here also, so we'll come back to the original filing, but this is the motion for recusal. They say, since we're suing all of you, now get off the case and send these to another district. Plaintiffs, the United States of America and Homeland, now respectfully request that each judge of this court recuse himself or herself from this matter. And Zenas might be a themselves. I don't know. Plaintiff also requests that this matter be referred to the Fourth Circuit's clerk office for reassignment of a randomly selected district judge from another district or transfer all the cases to another district. So get off since we're here. Now, first, because this court and judges are now named defendants because we're suing you, each judge in Maryland is required to recuse themselves from the matter. A judge shall, under the rules, disqualify himself from a case in which he is a party to the proceeding. We're citing the guide to the judiciary policy. It's your own policy. Even we are not above the policy, judge. Pack your bags. Policy says, when all sitting judges of a court are named as defendants in a civil action, each defendant judge is ordinarily required to recuse from hearing the case under the canons of judicial conduct. Judges have accordingly recused in similar cases, and so you need to do that now. Saying recusal is also warranted under the more general standard under a different provision of the law, which says, actually, you should recuse yourself of any proceeding in which your impartiality might reasonably be questioned, including like when your wife and daughter are Democrat affiliated and adjacent entities. Saying, here's an objective inquiry would lead a reasonable observer to say these judges are biased and should recused, since they're now being sued. And second, our request that the clerk contact another court is to facilitate a judge who actually can hear this case. Specifically in these circumstances, the Fourth Circuit explains how we do this. We just follow this rule in different district court. They then contact randomly selected judges and they serve and recuse. Oh, pretty common. Once such a judge has agreed to preside, then the JSO nominates the chair, and then they transfer certain civil cases transferred out of there. And there was a conflict with the current judges, so they just moved it. And so accordingly, we, Trump, respectfully request that all judges in Maryland recuse themselves. Get off the case. Plaintiffs also request that the matter be referred to the Fourth Circuit's clerk office for assignment and transfer to a better judge duly selected in a different district. And so get your cardboard boxes, judges, and take those cases off your desks. So what you can see is that's just part one. Now, they also submitted this in a much broader filing. They say, we are suing you, and this is what we want. So while this is pending, you guys got to recuse yourselves from our cases and this case. And now we are asking for more. Writing, plaintiffs, the United States and Homeland Security and America through Trump bring this action for a declaration and injunction. We want the court to force them to do or not do something. They write, all right, judge, in the District of Maryland, but these judges cannot hear it, right? So this case should be heard by some other judges because they're defendants. And so we're sending it to Maryland, but the judge should contact another judge and have them hear this case and reassign it. It's all by operation of law. Then I think you might argue that in the other cases, right, just to be clear on this, that the Kilmar cases and like the cases that Judge Zenas is on, you'd file, which we might expect to see, a motion to recuse from that case. So we haven't seen that yet, but but I would expect to see, judge, we're suing you. You're sued, get off the case. See the same thing happening probably in Chung's case. Get off the case. They're suing, you're presiding over this case, but since you're a defendant now and we're suing you, you gotta go. So here's what they write. All right, several hundred years of history, court, new judge, they teach that injunctive relief is an extraordinary, equitable remedy that is never awarded as of right. Okay, if you're gonna force somebody to do something, issue an injunction, you have to do this, or you can't do this, right? That's like a mandate to a person's personal activity. That's a big deal. You can't just do it willy-nilly. Is an extraordinary equitable remedy whereby you're trying to balance the scales of things, and it's never awarded as a matter of right. You don't just come in here and just say, I like an injunction. Oh, sure, here you go. Even where a plaintiff claims that there is going to be irreparable harm. Okay, it's a high standard, in other words. And injunctions against the executive branch are particularly extraordinary, extra high, because they interfere with that democratically accountable branch of their constitutional powers. Okay, if you're going to stop the president from doing something, there are mechanisms built into the Constitution and into our society to do that already. You can impeach the president. If there's a popular uprising, people are mad that Trump's deporting all these illegal invaders from our country, well, they can just complain to their representatives, the ones who aren't representing illegal aliens. And then they can join the ones who are representing illegal aliens, and they can have a majority and impeach and remove the president if it's so egregious. But it's not. And so what they have to do is take a different avenue and use injunctions to exercise powers that they do not have. It is a usurpation of our power, our right, and our structure of governance. Saying here, the core Article 2 powers to enforce the nation's immigration laws and shape and manage its relationships are all being usurped. Despite these elementary principles, what these judges in Maryland can't figure out, in recent months and years, district courts, especially Zenas, have used and abused their equitable powers to interfere with the executive branch to an unprecedented degree. In the first 100 days of President Trump's current term, district courts have entered more nationwide injunctions than in the 100 years from 1900 to 2000, requiring the Supreme Court to intervene again and again in recent weeks, and they're getting scolded for being so pathetic and hands-off on this, to pause the unlawful restraint of our Article 2 powers. Now, this lawsuit against these judges involves yet another regrettable example of the unlawful use of equitable powers, which are these injunctive powers, to restrain the executive. Specifically, injunctions are a remedy in equity. So when they say equitable powers, they're talking about the court being able to force or prevent somebody from doing something. Specifically, defendants, the judges, have instituted an avowedly automatic injunction against the federal government for basically anything, issued outside the context of any particular case or controversy. And they did so by promulgating a standing order. We covered this some time ago. And an amended standing order that require the clerk to automatically enter an injunction against removing, changing the legal status of any alien detained in Maryland who files a habeas petition, right? So the judge basically set in a new policy, like an email autoresponder, essentially. So someone files a lawsuit and an illegal alien gets rounded up by Tom Homan. He's like, you're going home. No more papooses here. So they put him on an airplane, or about to. They file a motion for a habeas petition. Illegal alien says, no, don't take me out. ACLU gangbang lawyers come crashing their clown cars right into their front door and then represent them. And once that habeas is filed, then the judge has said, you know what? I'm not even gonna look at it. Soon as it comes in, like you file it with the court, the paperwork goes out electronically, that gets submitted. Then what you'll see is the judge sets up like an AI chat GPT or whatever. It just automatically says, oh, that's a great petition. We love illegals here. You're an illegal? Habeas? Granted. Issues an injunction, right? So automatically it just comes right back. The clerk is directed without reviewing the case. The clerk's not a judge. The clerk doesn't get to say whether it's a valid petition or not, or whether there's good cause to issue an injunction. It's not automatic. Trump has the presumption of fair operation and good dealing to deport these people, as has been the tradition since forever until Trump came into power. So automatically, just email autoresponder goes out. Actually, you're injuncted. What? They say you can't do that. You're the judge. Now, the challenged orders here do precisely what the Supreme Court has forbidden. You can't do this. They are making equitable relief, an injunction, a matter of right. Soon as an illegal files it, boop, injunction granted. Free injunctions for illegals. You would never get an injunction if you say, the governor is shutting my business down for COVID, and they say that I have no right to my own private physical property. I can't open my doors and enter private contracts with other people who want to come in and get their haircuts. And you have to be locked down for that. You go to a judge and say, Judge, I'm a citizen. I've got rights in this country. They say, get out of my courtroom. They're going to kill everyone in here and throw you out. But if you're an illegal and you're being processed by the federal government and you're following orders of the executive branch, which were these governor executive orders, then you're free not to go. They're going to keep you right here in this country where you shouldn't be. So defendants' automatic injunction from these lunatic judges issues whether or not the alien needs or even seeks emergency relief, whether or not the court even has jurisdiction over the alien's claim. claims. Like, didn't even look at it. They file it right? No matter how frivolous their claims may be, it's automatic. And it does so in the immigration context, and thus it is intruding on core Article 2 powers under the law. The automatic injunction is motivated by the judge's, quote, frustration, their word, in quotes, not ours, with hearings related to the immigration enforcement actions and a desire to avoid handling cases outside the regular business hours. He's like, these illegals keep filing like at 2 in the morning. Trump puts them on an airplane at 2 in the morning. Their gangbang lawyers file a bunch of documents, 2:15. Judges go, ugh, plane's taking off at 2:30. They got to issue an injunction, get out of bed and do their job. And they don't want to do that anymore. So they just set up an autoresponder and they say, well, that's too bad. But a sense of frustration and a desire to greater convenience does not give them license to flout the law, judges, nor does their status within the judicial branch. Just because they're little dictators up there doesn't mean we got to deal with it the rest of the country or accept it as the DOJ. And so the judge's standing orders defy the requirements for issuing an injunction. There are rules that you have to go through before you grant an injunction. You can't just automatically do it. They violate congressional limits on the district court's jurisdiction over immigration. You can't even hear these cases. You're an Article 3 court. Immigration courts are Article 2. Always been that way, since, modern era. And they disregard the procedural and substantive requirements for issuing what amounts to a local rule. They are also fundamentally inconsistent with the judicial role only to accept cases and controversies, and they're predetermining a case without even looking at the documents. They're essentially presumed valid when that is not the law. Now, in particular, the district courts lack jurisdiction to hear challenges arising from removal proceedings or even issuing orders to enjoin or restrain the execution of those removals. Congress has expressly and intentionally channeled challenges to removal proceedings to specific court process in the Court of Appeals and imposed various other bars on judicial review. So these judges are meddling in cases they have no power to meddle in. Their automatic injunction extends relief as of right that district courts lack jurisdiction to issue. Okay, they're seizing power, granting benefits to illegal alien invaders. Now they're getting sued. Every unlawful order entered by the district court robs the executive branch of its most scarce resource, time to put policies into effect. They're stealing our term. In the process, such orders diminish the votes of the citizens who elected the head of the executive branch. Oh, that's us. Yeah, the citizens of the country. Defendants, the judges, lawless standing orders are nothing more than a particularly egregious example of judicial overreach, interfering with the executive branch and undermining the democratic process. They're not elected judges. They're not accountable to the people in any way. You could say, okay, maybe through impeachment proceedings, and I would agree with you, and we should have Congress start opening these impeachment proceedings. We've been advocating that for a long time. Start throwing that power around. Where has that been? Why are they tolerating this? Why don't they get rid of these circuits if they want to? Plaintiffs are entitled to prompt relief from defendants' unlawful and anti-democratic orders. And so we're suing all these judges, Russell and Abelson, and you know the rest of them, saying they're a judge of Maryland. They're all there. Same thing for all the judges, all getting sued. Here's what happened. Now, on May 21st, not long ago, the judges, they came out with this new standing order. They said illegal aliens are better than everybody, and so we're going to give them special privileges. Not only due process, but due process plus, due process premium version of America, because they're better than you. The standing order applied to all cases filed on or after 5 p.m. It purported to invoke the All Writs Act and a limited judicial power to preserve our jurisdiction and maintain the status quo. This is why we can do it, because we want to. The standing order also provided that as soon as they file a writ, they are enjoined and restrained from doing anything. You cannot alter their status. As soon as they file it, right, it's granted. What? The standing order provided that an order to this effect shall be entered in every case upon its filing. Soon as the doc hits, email autoresponder goes out. The standing order provided that its term shall remain in effect until 4 p.m. and there's like an end cap on this so that we can actually get the case and then, review it and those things. The standing order directed the clerk to docket the standing order in each relevant case. Okay, so in other words, the clerk gets to decide, oh, a petition came in, it's valid, injunction granted automatically, at least a small injunction. The judge realizes he can't, just automatically grant a permanent injunction. So just a little bit one. And then he'll come back and fix it later. No, you can't do that. And you're going to let your clerk make that decision? If you want to get your butt out of bed, judge, and make this discretionary decision yourself, you can do that. But you got to look at it, not her. The standing order stated that it was promulgated to preserve existing conditions and to ensure that they can participate and they don't get fueted out of here. So on May 28th, they amended the standing order and it was signed again by the chief judge. No effective date on that one. And it says that after filing a petition, you must also give everybody a copy of the order and you cannot remove them. Then we can challenge it later, reviewing what the order says. Now, this is causing a big problem on federal immigration enforcement. Explaining from Trump's perspective, since we're suing the judges now. Trump sues the entire district in this case. He says, the primary mission of ICE is to promote homeland security. Now, before it was to facilitate cartel invaders into our country. Detention is an important part of that. You know, an alien may enter and exit ICE custody on more than one time. And when you implement these orders, it really impacts our capability to do our job. We have a lack of bed space in Maryland too. So when we transport them, we capture them in Maryland, we got to send them out. Now, the orders do not afford our teams any opportunity to contest their assertion. We're going to pick them up from Maryland, send them to Texas. They're going to be housed there. They can file their habeas petitions there. They said, nope, can't move them out of here. Moreover, the orders invite aliens to say that they were in Maryland at the time. So they're exploiting this. This problem has already materialized, making us transfer people around. And it's causing a bunch of problems, adversely impacting the operational planning necessary to move these people around. And also aliens are traveling with fake documents and expiration dates. And you're saying we can't move them around? The order bars ICE from implementing final orders of removal by removing the alien. We got court orders and you say we can't do it? What? The order even bars immigration judges in a separate provision, in a separate article and basically entity from proceeding in the immigration proceedings, including by issuing a separate removal. He's taking the immigration judges' jurisdiction away from them. Says the order also may bar courts of appeals from acting and more. So overbroad. It bars the alien from receiving other immigration-related benefits that would change their status, like even benefits to them. And it's already been entered in multiple cases, disrupting our immigration operations and more. And we face barriers in seeking review because everything is being stalled. Piecemeal appeals of cases are entered. Similarly, it's not a sufficient opportunity for us to take these up on appeal. And so now we're suing you. Here's our claims for relief. You're violating the law, all of you judges. Courts have long recognized that even absent a statutory cause of action, the United States can sue. And guess what? That's what we're doing. Standing orders are only permissible if they're consistent with federal law. You can't just change the law on injunctions by executive order and fiat. Courts must also consider the four-factor test by the Supreme Court before issuing TROs, and you did not do that. Supreme Court has explicitly said you have to follow certain rules, and you're not doing that. Now, the orders purport to issue ex parte, right? Trump's not even having a say in it. They filed their petition. DOJ has no say. The judge just says, you win, injunction. It's really a TRO, but it's, basically an injunction, without meeting any of those requirements. They do not require any specific showing of any of things in the test. Irreparable harm. There's no affidavit or verified complaint. They don't require a written certification. They don't provide any why notice issues are not problematic or are problematic. The orders do not satisfy the requirement of any of the description the court has to provide, showing why there is immediate and irreparable injury. Now, if the orders were instead understood to direct the entry of a preliminary injunction, which you could argue they are, they would also be unlawful. They may only be issued on notice to the adverse party. And generally the sequence, as we've talked about, right? You get a TRO. It's very temporary to stop the imminency. Then you prep for further briefing. Then you come back and argue the preliminary injunction. But essentially, judges are treating them, they're causing the same outcomes, which are permanent stops to Trump's efforts. So you can call them whatever you want, but they're ultimately just stopping Trump. Now, they must be supported by statements of reasons for the injunction. They're not giving them any reasons. They're also violating jurisdictional bars, these judges. Congress has stripped federal courts of jurisdiction to hear any claims based on removal. That jurisdiction goes over to the Article 2 courts. This section is known as the zipper clause. It channels all review of any actions taken or proceedings brought to remove the alien from the United States under subchapter 2 of the INA into a petition of review that's filed in habeas in their location of confinement. Another provision also bars judicial review of these decisions. Habeas is the only way they can do it, but despite all these restrictions, the judge says, actually, I'm the president now. Expressly stops us from removing these people, plainly exceeding the scope of their powers. And so we also say they're violating their own local rules, for crying out loud. Courts will write their own local rules, and they say that local rules may only be adopted via notice and comment rulemaking. And so the fact that you issued a standing order on all cases, you can't even issue a standing order unless you go through the due process of issuing a standing order. The judges didn't do it. Judges gave nobody else due process. Trump administration didn't get any due process. The American people who elected Trump and this administration to effectuate these removals, we don't get any due process. And the court, when they're issuing their orders, don't even provide due process according to their own rules. But the illegals get everything they want. And now they're being sued. So we're excited to see what happens in response to this. And we expect to see other motions of recusals in the other cases, perhaps the Kilmore case in front of Zenas and more. But Tom Homan was saying, look, we're going to continue to remove these people. These judges are trying to injunction us to death. path. But as soon as we get this big, beautiful bill done, we're going to remove these national security threats. We're going to do it with haste. Tom Homan on what's coming next.
Well, look, we got a lot of work to do. You're exactly right. Which, again, I want you to jump in. We need a big, beautiful bill. We need the funding for more agents. We need the funding for more beds. We need the funding for more transportation. We need the funding for more targeting. So it's imperative, especially right now. So for those on the Hill, I don't care. Removing national security threats, removing public safety threats from this country should be a nonpartisan issue. So get it done. We need the funds to get this done. Well, the good thing is President Trump, we got President Trump in the Oval Office. I can tell you, right after the election, we didn't wait till January. We didn't wait for the inauguration. Right after the election, I got together with a lot of smart folk to say, okay, we got a big problem we're going to deal with right after the inauguration on 2 million plus gotaways and all these special interest aliens that were released into the United States. So we started planning for this months ago. So on day one of the administration, we're hitting the ground. That's why President Trump from day one said, we're going to concentrate on national security threats and public safety threats, and that's what we're doing. After the Iran issue this weekend, we just stepped on the gas, adding a lot more resources to it and really hammering it. So we're on it. We're going to do the best we can as fast as we can.
All right, Tom Homan explaining judges can try what they're trying to do, but we're going to stay after it and do the mission that we were sent here to do. So we're excited about that. We're going to keep our eye on this case. Thank you for subscribing and joining on this. We're going to see what the Trump DOJ does in this jurisdiction and others. Maybe we'll see this same lawsuit filed in the District of Columbia.